Hi guys, welcome back to Battle with Ola once again. This is Mojola Oluwa, and on today's episode we want to talk about what does a state council do too. We've talked about what does a state council do. I've said that we'll have it in about 4 parts where we talk about the things that a state council does, for its employer, and I'm going to be talking about it from my own experience. So in the last episode on that series, we talked about what does the state council do, and we talked about receiving bail applications and the steps that the state council takes. We talked about tracing the court file, tracing the substantive matter, finding out if the state is charging or not, and filing a counter affidavit. So in this episode, we're going to be talking about moving the counter affidavit. That's one of the things that the state council does. I think that we've already done a video on moving counter affidavits on this channel, but if not, this will suffice. So now there's a bail application before the court. A bail application is the defense counsel asking the court to let their client go temporarily. That is, let him come and answer the case against him from his house, So bail pending trial. Then the state will then respond to that and say, no, he cannot. We need him in custody, or say, yes, he can go and answer from his home. So many things go into play, which we've discussed in the last video. But now we're before the court. We have filed. I am the state counsel in this scenario, and say that I have filed my counter affidavit and it's time to move. The court wants to hear both parties today. So the court will ask, after we announce our appearance, the court will ask what we are here for, and then the person that has filed the bail application will say that, my lord, we are here. We have an application before the court. It's dated and filed so and so. And then the court will ask if I have been served or if the state has been served. Yes, my lord, we've been served. What's your reaction? My lord, we are opposed to the application and we have filed our counter affidavit. Then the court will hear us. So this person will move their bail application, and then it will be time for me to move my counter affidavit. Then I would say, my lord, we also filed a counter affidavit. It's dated 10th December 2023 and filed on the same date, my lord. My lord, our counter affidavit is deposed to by one Counsel Joyce, a litigation clerk in the Department of Public Prosecutions. Supporting the counter affidavit is a written address, my lord. We seek to rely on all the paragraphs in our counter affidavit, and we adopt our written address as our argument in the matter, my lord. We urge your lordship to deny the applicant's prayers in its entirety. We're most grateful, my lord. We humbly urge your lordship to deny the applicant's application in its entirety. We're most grateful, my lord. That's how to move a counter affidavit. In addition, you could also adumbrate, which is needless but can be permitted. Adumbration just means that you emphasize some parts or portions of what you filed before the court. So you could say something, for instance, in the sample that we used in the first video, we talked about how some of the things in the affidavit were false, and then we had said that this is the position, this is the position, this is the position. In one of them, I think we said that the applicant had been granted bail by a court, and then they had gone on to commit another offense. So you could adumbrate on that and say that, my lord, it's important to underline the fact that the applicant is a repeat offender, my lord. My lord, the applicant was granted bail in court so and so by your learned brother so and so, and he jumped bail to commit this offense. And so, my lord, it will be against the interest of justice to grant this same applicant bail, because this applicant has shown contempt and disregard for the court and the sanctity of the discretion or discretionary order of bail. You could bring up so many things according to what you have filed before the court, because we're talking about facts here. Counter affidavit, written address. So facts, decided cases. My lord, in the case of so and so, which we have filed or which we have cited in our written address, the court held that in instances of murder, it goes against the grain of justice to grant an applicant or a defendant bail. My lord, granting bail in this instance may even be inimical to the security and safety of the lives of the defendants or applicants. My lord, this is a matter that has spurred a lot of public anger and fury. My lord, to avoid a situation where the members of the public might take laws into their hands or commit jungle justice, it is important that the defendant be kept in the custody of the state pending the determination of this case. My lord, it is true that bail is discretionary, and an applicant or a defendant, and indeed every Nigerian citizen, has the fundamental right to freedom of or liberty, freedom of movement, my lord. But in this case, my lord, it is in the interest of all parties, in the interest of justice and law and order, that the applicant be kept in custody of the state while the trial goes on. We urge your lordship to refuse the application in its entirety. We're most grateful, my lord. So you could say any other thing, in support of your case based on the peculiar situation or circumstance. In a matter where we had to file a counter-affidavit, when I traced the file, I noticed that the defendant, had it was a multi-defendant case. So there were about 4 defendants. One had jumped bail, 2 had jumped bail. Now there were just 2 being held by the correctional services, and then the lawyer had come and said, grant one of these persons bail, they are my clients. So I also told the court in my counter affidavit that 2 people have jumped bail in this matter, and they're already stalling the matter. Granting another person bail in the matter is going to just frustrate the case. So many things depending on the circumstances of the case. You could also say something like, which happened in another matter, that the trial is already ongoing in another court. So why not just transfer this bail application to that court? Or why not just, since trial is ongoing, let the trial just run its full course, and then let the applicant know his or her fate in good time, instead of, going about bail applications. Of course, these things will not sit well with the defense counsel, and they will also have their own things to say and points to argue. But at the end of the day, bail is discretionary, and it is the discretion of the court to exercise it as they see fit. Now, there are some defense counsel that take things personally, and they think that it is them versus the state counsel. This is this is not a cool, disposition to assume, because in the real sense of it, it is not. Both of you are working towards the end of justice. You think your client is innocent. We think the client is guilty, but the judge will look at our evidence and the facts, and decide for the society. So it's really not us versus you. We're just trying to work towards the end of justice. I remember, I recall that, I think I've shared it on the channel before. A state counsel was, a defense counsel was being so condescending. He referred to me before my lord as this lady. He said, my lord, I think I was so angry. I was like, I don't know what this lady is saying. Now, another thing you need to notice that, because the chambers of the Attorney General consist several state counsel, sometimes the person you think is handling your matter is not the person handling your matter. So when you come with ire and fury against that person in court, you may be attacking the wrong person. So this particular day, my colleague was the one that had handled the matter, and that had something to do with this particular defense counsel. So when I had to go and continue it because she was otherwise engaged, the counsel now brought his anger that he had prepared for her on me, and was even referring to me by a name. The court had to correct her that this person is so and so. The court told him my name, that the person that you think you're addressing is so and so, who is not even here today. And he was like, my lord, this lady is... My Lord had to correct him. I'm thankful to my Lord for that, because I did not even have to say anything. That my Lord had to correct him and say, you don't address your colleague as this lady. You know, we are all lawyers at the bar, so we are counsel, you know, whether male or female, young or old. So very important. Keep your emotions at bay. It's the substance that matters, not necessarily how you feel or your emotion. In another instance, when I told the court that the matter was ongoing in another court, and that trial had already been opened, and so the accused person or the defendant should not be granted bail, and also because it was a murder trial, you know, the defense counsel got up, was furious, was very angry, you know, and then he said that he couldn't believe me, that I have nothing to show to the court, that trial had indeed begun. The court agreed with him, and I had to take a day to put my house in order and bring proof to the court that the matter was actually ongoing. I think I've said this a few times on the channel. And then, you know, after that, he went on being pesky and telling the court that even though the trial is ongoing, so and so is the case, so and so is the case. And then my Lord now cited a Court of Appeal judgment to put him in place. Then he cited a Supreme Court judgment to my Lord to say that my Lord was wrong. At the end of the day, you know, since he did not believe me, despite the proof that I put before the court to say that, oh, it's a murder trial, oh, the case is ongoing, oh, this and that, I asked the court to transfer the bail application to the court, because there were so many preliminary matters that we were just addressing, and it kept on going on and on and on. Another thing is that you need to learn the language and the body language of the court. Of course, know what your judge is predisposed to, and the disposition of your judge towards certain things. And then you need to learn the history. Not necessarily learn, but just try to familiarize yourself with the history of cases in a particular court. It's easier for state counsel because in most cases, you know, they are stationed in one court. I was in one particular court for almost 2 years, and then we had matters in other courts, but I was in that particular court primarily with my superiors. Of course, it wasn't my court, you know, so we already knew the disposition of the judge to some things. Some defense counsel do not have that, so that's part of what a state counsel does. So you already know that if it's this application, this is what the court will likely say, this is what the court may likely do. You know, so he was coming from another jurisdiction, and then he was being somewhat pesky, but we were able to transfer the matter to the court where the substantive matter was being conducted by another state counsel to see if the judge there would grant bail in a murder trial. So that's another thing. I remember also that I had gone to this particular court where a murder trial also was ongoing for several years. So one particular defendant had jumped bail, and all efforts to get him had proven abortive. The court had issued a bench warrant. We had followed up with the police, with the correctional facilities and everything, but nobody could, you know, determine his whereabouts. You know, it was like a multi-defendant case. There was about 5 defendants with 5 different lawyers. One of the lawyers had even told the court that he had seen the defendant, and because the defendant's lawyer died, you know, at some point he told him that since his lawyer has died, the case has ended. So the court was like, can you bring him? You know, you shouldn't even be saying something like that anyway if you're a lawyer, but he was not able to bring him to court anyway. So we couldn't find him for a long time. So there was this particular day that I went to court to get an adjournment for us to continue to look for him, because for some reason the police, they don't have an efficient way, and the correctional facilities, they do not have an efficient way of tracking down defendants who jump bail in Nigeria at the moment, at the point of recording this video. It's a big challenge, and that's why most times state counsel, if they see that they have witnesses and their cases or their case is strong, they don't want to they want to oppose your bail application as defense counsel, so that this defendant will not also get away. Let's do it. Let the court decide if they are guilty or not once and for all, instead of giving them bail and then they abscond, they jump bail, and then nobody can track them. I would even think that in some instances, some people take bail so that they can actually jump bail. Before I became a state counsel, I was practicing in a jurisdiction where I went to court for almost the whole of 1 legal year, defending my client who kept showing up in court who had been charged with 2 other persons. They had been charged with murder, but he had been charged with receiving stolen property. Allegedly they had killed a university professor and then stolen his phone. And then my client, he flashes phones, puts music on phones, and for some reason something had happened, one thing had led to the other, and the police had arrested him for being in possession of the professor's phone. Of course, it was not exactly the picture, but let me not go into the details of the matter. So he was charged for receiving stolen property. They were charged for murder. Someone had taken their bail, and then they absconded. They jumped bail. So for about a year, I kept on going to court, showing up in court. Sometimes their lawyer would not come. We were all defense, so their lawyer would not come. My lord will acknowledge the fact that I came. My client is in court and everything for about 1 legal year, until one day we were able to get their lawyer in court, and my lord descended heavily on him. I think I've also referenced that on the channel. So this thing happens whether you're defense counsel or whether you're prosecution counsel. Jumping bail is an unpleasant reality in the Nigerian legal system, and that is why sometimes state counsel are more predisposed to opposing the bail application. Let's decide the matter once and for all. But also, we must acknowledge the fact that bail is discretionary, and it's a kind of entitlement, yes. So sometimes, or especially in simple cases, simple offenses, it's important for the accused person to be able to have their freedom to do some other things while the case against them is being decided. This is why a state counsel sometimes opposes bail applications. So that particular day in court, the court descended heavily on me, and it was not even my fault. As a matter of fact, I made this case when I was employed, but because there was this person had jumped bail, the case had been paused for about 2 years. While all parties involved were busy looking for. We had even contacted the OC Legal, done everything possible, but we could not procure the presence of that particular defendant in court, and the lawyer that was representing him had died. So the case was paused for so long. So the judge was very mad that particular day. He descended heavily on me, insulted me, did everything that he could, but then thank God my colleague was with me. It was a terrible day. It was a terrible day because I just went to suffer for the sins of my ancestors in prosecution. So, but anyway, we got through the day. So this is one of the things that state counsel do, or that they go through. They oppose bail applications. After the counter affidavit has been moved, the court will then adjourn for ruling. So the court could give a bench ruling. It's not a usual practice at the High Court. It could be at the Magistrate Court, but my practice was at the High Court mostly. So the court adjourns after both parties have moved their applications and counter, for ruling. So the next time parties come to court, the court will deliver the ruling to say that, okay, I am admitting this person to bail on so terms and conditions, or to say that the bail is refused, which is a win for the state counsel. So that is how the state counsel moves the counter affidavit. So if the bail goes through, the trial can continue if parties are ready to continue, or the court can adjourn, to open trial. But if the bail does not go through, in most cases, the court may make an order as to accelerated hearing. That would mean that hearing should take place immediately and on consecutive days, so that the case can be tied up on time and parties can know their fate. So this is one of the things that the state counsel does. They oppose bail applications, they move counter affidavits, and they take the ruling, after which both parties know what to do next. And these are some of the reasons that I've espoused as to why they are more predisposed to opposing the bail application than to not oppose. But the fact that the state counsel would likely oppose the bail application does not mean that the defense counsel would not apply. You weigh your options, you look at your case. I've spoken about a matter, it was an attempted murder matter, and because the attemptee and the attemptor were from the same family, they are settled at a family level, and according to their story, it was an accidental discharge between members of the same society who were also family members and all of that. So they wanted the state to withdraw the charge, but I did not have that instruction from my superior. So when I went to court, I told the court that we're ready to prosecute and that we have gathered our witnesses, which I had already done, before that particular date. So I advised the lawyer, why not just apply for bail in this instance, and or go and sort out how to withdraw properly, because I cannot withdraw for you. I am the state that charged them to court. You cannot ask me to overrule what I have done, what members of my office have done, not particularly me, just because you have now decided that you don't want to go on with the matter. You are the ones that reported to the police in the first instance. So you cannot just be crying wolf and, making the government's business child's play, because especially because in that particular matter, apart from the fact that they were weaving it into an accidental discharge, which was attempted murder to the state, the gun was also unlicensed. So even if the state would say, oh, because you are family members, we're not prosecuting you because it was not a malicious discharge, how about the unlicensed firearm, which is a crime on its own? So I advised the lawyer, I said, take their bail, apply for their bail. But he did not listen to me, and the case went as it was wont to go. So sometimes as a defense counsel, you weigh your options, because you cannot expect the state to do everything for you. In another matter, the counsel had expected us, because they were trying to prevail upon the victims not to press charges that were already before the court. Then the counsel was trying to prevail upon us, me, my team members, not to oppose their bail application. But, that's not our business. This is an armed robbery matter. It's a serious crime. We have to oppose the bail application, because what if you're on bail and you go and commit another crime? People's lives are at risk, because sometimes defense counsel don't look at it other people's way. In a kidnapping matter, how do you apply for bail and expect that the state counsel will not oppose your bail application? You want the attempted kidnapper, allegedly now, because the court has not decided. You want them to go out and do something else, especially when there's overwhelming evidence which would likely convict them, if the judge or the court is convinced. No, it is not the state's business to play ball with you or to help you, give you a soft landing. It is our own duty the duty of the state counsel to do what is needful, what is necessary. So that is some of the things that you weigh, when you're looking at bail applications. And sometimes after the state has filed and moved a counter-affidavit, the defense counsel could come and file further and better, affidavits, to support their bail application. Yes, some defense counsel can do that, where they are bringing new facts in their affidavit before the court to say that the court should actually hear them. So it doesn't really terminate all the time at the counter affidavit level. But when all this is placed before the court will weigh everything and then decide what to do. So that is why in some instances you could see that, oh, it's a murder trial, this person is on bail. And then you see that it's another murder trial, but this person's bail application was refused. So many things go into play. And then sometimes some defense counsel will file affidavit of urgency. Sometimes it's not really urgent. When they say that, oh, the defendant is sick, is in need of medication, most times they say that he had a doctor treating him, or he uses some herbal concoctions and he needs to go and take it from this time to this time and all of that. If the court is convinced, fine. But whatever you're putting before the court, know that the state has the prerogative of opposing it, depending on what type of matter it is. So for serious offenses, the state is often predisposed to opposing the bail application. Murder, armed robbery, kidnapping, those serious offenses. But for lesser offenses, where, the applicant being on bail does not really pose a threat to the larger society, and maybe there's a likelihood that they would actually answer for their case, the court, the state counsel may not oppose, but nothing is cast in stone. It's all based, it's a situation by situation affair. So you also need to know this. Very important. So what if the state counsel is not opposing? On the date slated, or when the matter is slated to be heard, the motion, when the court says, have you been served? And we say, yes, we've been served. What's your response? My lord, we are not opposing. The court will then ask, on what grounds? And then would present our grounds to the court. For instance, in the case of arson, arson is 14 years. It's a bailable offense. So we would say things like, my lord, it's a bailable offense, even though I don't think arson should be bailable, because, you know, someone has set someone's property on fire. You want to unleash them back into the society without, of course, you know, the matter has not been decided. So the most important factor that a state counsel and defense counsel must always agree on is that there's no conviction yet. This person is innocent until proven guilty. That's the most important factor in criminal trials. So bailable, so that's one of the grounds. It could be on what grounds? My lord, the state is not charging. The legal advice is out, and the state is not charging the defendant, or the state is not charging the applicant, because they are not yet defendants if there's no charge yet. So it could be bail before a charge is out. You know, sometimes if the legal advice is taking too long and a person is in custody, their lawyer could apply for bail, you know, even at the High Court. And then when it's time to oppose, if they have not been charged, the state counsel will say, my lord. When the court says on what grounds, the state counsel can say, my lord, the state is not charging them, or they have not been charged. Legal advice is out and they have not been charged. Or, my lord, it's a bailable offense. That's the most common ground for not opposing. Also, it could be that it is the DPP's specific instruction not to charge. You know, the DPP could be acting on the constitutional right of nolli prosequi, you know, that is conferred on the Attorney General. You know, because we are all counseled in the Attorney General's chambers, you know, we can exercise that right on his behalf. Even though, if you read the Constitution, some people could argue and say that only the Attorney General can exercise that right. But members of his office can exercise the right of nolli prosequi on his behalf. So it could be that on what grounds we have the DPP's instructions not to oppose the bail application. So that's something that State Counsel also say. I've done a video on nolli prosequi on the channel. Please watch it. I've also done a video on the A to Z of criminal prosecution in Nigeria, where I chronicle all the processes, you know, from arrest to conviction, even appeals. So please watch those videos. Check the playlist on criminal prosecution. So we're going to stop here. In the next video, we'll talk about other things that a state counsel does. And of course, from my experiential point of view, I'll tell you about amending charges, about bringing witnesses to court, and some other things that a state counsel does. I will see you in that very video, or the next video if that's not it. Toodles!